First of all, what are pre-action protocols? We've got to cover this because it is new and it has changed fundamentally the approach to debt recovery when you're claiming from individuals. Where do protocols come from? This isn't going to be a legal history talk, but Lord Woolf, when they were looking at the civil procedure rules that then changed, I think, in 1998 from memory, reported and said we need protocols to build on and increase the benefits of early but well-informed settlements and genuinely satisfy both parties to dispute. Litigation is a last resort. Promote at an early stage options for resolution, and if a dispute can't be settled, to at least narrow down the issues and identify what you're arguing about. So it's hard to argue with any of those observations. And there's a whole raft of protocols. This is broadly the chronological sequence of how they came in. There was one initially, that was the personal injury protocol. You can see how they've grown across all these different work types. And initially they were aimed at what could be possibly more complex cases. If you've got an injury, then you produce medical reports, so you can have prognosis for how you would react to treatment and what compensation you would get based on medical expert evidence. Construction engineering, there's surveyors and engineers about what was wrong with buildings and works, etc. All the way through to these types. And there's been discussion for years about a debt recovery protocol. At one level, you think debt's quite simple. We've provided goods or services, the bill's not paid. What do we need to exchange all this information about? But increasingly, the volume of debt litigation going through the courts, and it is the biggest single case type running through the court, particularly from regulated debts, consumer debts, credit cards, overdrafts, financial products, etc. So increasingly, concern about that type of debt litigation prompted some momentum to say we need a debt pre-action protocol. And they had a stab at it 2-3 years ago, but with consultation with the industry, it was put on hold and further consultation took place because it was far too onerous what the original consultation was. And the one that we now have is a product of that consultation, principally with large debt purchasers, banks, etc. No one really consulted with local authorities about your peculiar debt types because you've got a whole raft of different ones. But you're caught by it, although the driver for the protocol was that bulk financial services litigation. Came into force on the 1st of October, so I'm sure you've all got your processes in place so that you're now compliant with the protocol. It is very different. We've been pulling our hair out for months trying to change our computer processes, the letters, which fields go into which letter, what are the milestones, because it's fundamentally changed how you deal with litigation, debt litigation. But before we look at the protocol, just remind ourselves that what in essence was the process before the 1st of October. I put a 7-day letter of claim, but it was a letter of claim, whether it's 7, 14, 21 days. But you'd write your letter and you issued your claim. What could be easier? The letter was 1 page and the claim form was pinged off by a computer 7, 14 days afterwards. I accept that for residential home care debts, deceased debtors, it's more complex, but essentially that was the debt recovery process. The protocol applies to any business, but business includes sole traders and public bodies, that is claiming payment of a debt from an individual. So that covers all we're talking about today. But if you go back and talk to colleagues about the protocol and you're claiming from businesses, the protocol doesn't apply. So the previous slide, simple 7-day letter, issue a claim form, still works for commercial debt recovery. But for our purposes today, claims against individuals, we have to comply with the protocol. Now, the aims of the protocol, this is set out within it, but it mirrors my first slide about what Lord Woolf said in his report in 1996. It's to encourage early engagement and communication, to enable the parties to resolve the matter without the need for court proceedings, to encourage the parties to act in a reasonable and proportionate manner, and to support the efficient management of proceedings that can't be avoided. Now, you can't argue with that, and actually everyone in this room would fully embrace that if only our debtors would. But it's hard to argue with the idea you exchange information. But I think for our debt types today, residential home care charges, the protocol, my own view, it actually helps us because it will promote engagement with the people who owe you money. And we can refer to it to encourage them to engage with us. And if they don't, as I'll show you later, there may be incentives for them to do so. But what do we do then for the protocol? The original letter was 1 page long. The new protocol letter is 13 pages long if you do it one side. We've decided to double print ours so we can get it onto 7 pages. There is a debate that if debtors don't respond to a 1-page letter, are they likely to respond to a 13-page letter? Who knows? It's too early to give you any meaningful feedback about any change in debtor behaviour so far, but everyone's tracking it. So our new letter, why is it so long? The easy bit is you've got to put the amount of the debt in. You've got to put in whether interest or other charges are continuing. Now, I had a debate with Rachel earlier this morning about what other charges might be, because the intention behind the protocol was to identify other charges for the debt recovery process. So in a lot of contracts, particularly financial services products, they charge payments for late payments or arrears recovery, etc. It's to be open about those charges. But what Rachel and I think is that for some of your charges, you're chasing debtors who are still getting services in some cases, so the debt's increasing weekly or monthly. So we think it's a good idea in your cases to put those continuing charges in as well. So you're really embracing the spirit of the protocol, and when you engage with your debtors, if they engage with you as a result of the letter, you don't just want to collect the arrears, you'd like to get an understanding and resolve the future with them, so you're not chasing them for a debt in the future. So by putting the future charges in, it gives us an opportunity to try and resolve the whole issue with them about future charging, if they need for further assessments, etc., etc. You've got to put details of the agreement, whether oral or written. Now again, there's a nuance in your area because it's not always written agreement. Some of it is underpinned by statutory provisions, but the essence is you have to tell the debtor what the basis of your claim is. If they're paying you instalments, you have to recognise that and explain why those instalments are unsatisfactory. Because someone could be paying you £50 a month, think that's all right, that should cover it, but you think that will never clear the debt, it's getting bigger and bigger. So we need to say, your £50 a month won't cover the future charges, the debt will continue to increase, we need a better proposal. So you have to cover off those that are paying regular instalments. And the reason the letter's so long is that we have to enclose information sheets, a standard reply form. Copies are in your pack of what the standard reply form is, and a financial statement form. Now, those of you who are familiar with the documents that the courts send out with the claim form will see the similarities between the standard enclosures to a letter of claim to the documents that the court sends out, because the idea is to promote a response. Is there a dispute to the debt? Is it admitted? If it's admitted, they need time to pay. What are the proposals? Give you financial information so you can assess the reasonableness of any proposals. And the whole intention is to try and bring forward the response pack that you get when you issue a claim to before the issuing of the claim. It raises another question because if you issue a claim form, costs are charged on the claim form, and those costs are passed on to the debtor. Now, the costs that you were getting on the claim form effectively funded the recovery process. If the courts are now encouraging you to deal with matters before the claim form, then there's not a vehicle to add the costs onto the debtor, because there's not a contractual provision or a court rule that allows you to do so. So you have to grapple with the question about how you're going to fund this new type of work that's put before the claim form that was once previously after the claim form. We sent our letter out to the court, not to court, the debtor, and they got 30 days to respond. So the old letter was 7 or 14 days, so you can immediately see that the time span has extended now to 30 days before we can issue a court claim. If the debtor responds, then no surprise, you've got to fairly consider that response. If it's a partial response, the protocol says that it's to be treated as a genuine attempt to respond, so you've got to engage with it. If they say they want debt advice, but they can't get a booking from a debt advice agency in sufficient time to respond in 30 days, then the protocol requires you to allow reasonable extra time to obtain that advice. Where instalments are made, you should attempt to negotiate and resolve it by discussion and instalments if they're reasonable. There should be a relevant and early disclosure of documents. So that goes both ways though, remember. So don't view this just as a burden on you, because if the debtor's suggesting something and you reasonably need documents to assess it, you can refer to this protocol to say, please can I have copies of? So it should be a two-way process. So as I said earlier, I think this actually is helpful to resolving these more complicated debt types. If as a result of that process you haven't settled it, there's not proposals, and you remain in dispute, there's what the protocol calls a taking stock period, where you're meant to sit back and reflect on, do you really want to issue proceedings? How far apart are you really? What can you do to narrow the issues? Can you exchange any more information? And ultimately, you've got to then write to the debtor to say, look, I'm giving you a final 14 days notice that I'm now going to issue proceedings. And then you issue the claim. So you can see, I mean, I haven't done a timeline, and it's rather imprecise depending on the precise nature of the response of the debtor. But at its quickest now, if there is no response, the original 14-day period is now 30 days at its quickest before you can issue the claim form. And you can see if there is a process of engagement, a request for time to take debt advice, etc., it could actually be a couple of months before you get round, maybe 2-3 months before you get round to issuing your claim. So it's pushing out time limits for recovering the debt. But hopefully it will create more engagement with debtors, because none of us want court proceedings ultimately. So the courts expect the parties to comply and make it very clear that if you ignore it, the court can strike out claims, it can stay the claim whilst it requires you to exchange information. It can refuse to award costs even if you're successful. It can order you to pay the other party's costs. If a debtor then rushes off to see a solicitor and you've not followed the protocol, the solicitor might say, this could all have been avoided if you'd have followed the protocol, so we're going to ask the court for you to pay our costs. All those things might happen. But also, I think, as a reasonable public body and any reasonable organisation, so if our debtors won't engage with us, then this becomes a tool to help us, because we can then say to the court, look, we followed this protocol, this debtor refused to engage, we've had to incur all of these costs, please can we now have these costs on an indemnity basis? Or please can we get costs in situations where you might otherwise not have wanted to give us costs? So by us complying, it reinforces our ability to seek to recover the costs from the debtor. Now, one final comment is that after you've heard of Alison's talk on limitation periods, you might go back to your office and think, oh my God, we've got loads of cases that run past the limitation period tomorrow. Mark said we've got to serve the protocol letter, what do we do? Now, the first thing to understand is that the protocol letter doesn't stop time running. So if you send a letter and your time runs out tomorrow, you're out of time. You can still issue a claim, and that's one of the exceptions, but you don't have to serve it. You can issue a claim, you can hold it back for 4 months. If you need more than 4 months, you can apply to the court for an extension. If there are limitation periods, issue your claim, then follow the protocol process and issue your proceedings. But don't think sending the letter stops time running, because it won't.